The broadcast is now starting. All attendees are in listen-only mode.
Hello everyone, and welcome to today's webinar, Advertising and Social Media, Understanding the Legal Implication and the Do's and Don'ts of Native Advertising and Social Media. My name is Florence Chéron, and I'll be your moderator. I work with the membership team at the French-American Chamber of Commerce here in New York, and I'm excited to be hosting this session today. I'm pleased to introduce today's speaker, Ted Max, partner at Sheppard Mullin. Ted Max is a member of the Entertainment, Technology, Advertising, and Intellectual Property Practice Group in the New York office, where he focuses on counseling clients on intellectual property issues and litigation. He is leader of the firm Fashion and Appeal team. Ted combines his skill and experience as a trial attorney with his knowledge of copyright, trademark, and intellectual property law in servicing the firm's diverse clientele. Before I hand the mic over to Ted, I have a few housekeeping items to cover about this presentation. First, today's webinar will be available on demand. We will send you the link and presentation after the webinar. Next, we'd love to hear from you during today's presentation. If you have a question for Ted, please feel free to send it through the question tab. We'll be answering questions at the end of the session. If we don't hear from you, if we don't get to your question during today's webinar, we will be sure to follow up afterward. And last, we'd like to encourage you to share today's webinar with your social media network. We will be hosting the recording on our website and social media. So without any further ado, I'd like to kick things off by welcoming Ted. Ted, over to you.
Thank you, Florence. So as Florence said, the subject today is the legal implications and the do's and don'ts with regards to advertising and social media. A few years ago, I remember talking to a colleague about influencer agreements, and they didn't think that influencers would be a big deal. But as one can see from this slide, the average cost per paid post per platform has increased dramatically over the last few years, and the role of social media and influencers and native advertising are critical today. There is really a dramatic change going on in the world of advertising today. And so what we will address today is how the regulations of the FTC and the laws are dealing with social media, native advertising, and influencers. So first of all, let's talk about the basics. In 2009, the FTC came out with revised endorsement guides. And initially, the endorsement guides were dealing with things such as people endorsing products either on TV or in print media, and the idea of social media and online distribution of people's comments was not even really heard of. The basic rules are endorsements must be truthful. It has to be a truthful experience of an endorser. The claims have to be able to be substantiated. If an endorser received something of value or has a material connection with the advertiser, that needs to be disclosed. And as we'll see, that's a critical point. And if there's any financial or familial relationship with a brand, that needs to be disclosed. And as we'll see today, social media is no exception. So the questions that we will answer are, how do the endorsement guidelines work with regards to social media, influencers, and native advertising? What types of disclosures are required? Because as we know, with social media, oftentimes the ability to make a disclosure may be limited. in terms of space or in terms of content. And the critical question here is, what do advertisers and agencies need to know in light of the changes that have been going on with regards to the FTC's guidelines, especially with regards to Twitter, Facebook, Instagram, and some of the other platforms. We will also tell you and explain what the FTC has done recently in terms of enforcement. And in terms of that, there have been developments in the last 2 weeks that relate to what the FTC has been doing and what the FTC is advising people to do. So, and then finally, we'll go over best practices. So without further ado, let's jump right into it. The first question, the client, their director of marketing calls and says, can we give out to celebrities our top selling designs and then use their photos in our marketing materials and on our website? And the answer is, you can do that, but if you do that, the participants, if they're posting on their social media, they have to disclose that. And free samples are considered a material consideration, and so that gift of free materials or a product or even a video game, as we'll see, is sufficient that it needs to be disclosed. So the director of marketing states, well, Madonna loves our products and we have nothing in writing, but she always tweets and Snapchats about how wonderful our designs are. All it is a few designs. What's the proper way to make such a disclosure, and what's the big deal? Is hashtag SP sufficient? And hashtag SP, which is short for sponsor, is not sufficient. The FTC, in a variety of different publications and online online conference, indicated that hashtag SP is not likely to inform consumers that the message was sponsored by an advertiser. If you do hashtag sponsored, that works. Hashtag ad or hashtag ad in caps works. Ambassador is not sufficient. If you say Acme brand ambassador, if Acme is the name of the brand, that's sufficient. Again, thanks, Acme brand is not sufficient. But if one puts it in a narrative that says something in words or substance, thanks Acme brand for the gift of this beautiful bag, that is sufficient. This may sound very technical, but the FTC really has called people out on this. And so the difference between, let's say, hashtag SP and hashtag sponsored is a significant difference. And it's a difference that if one is an advertiser or an advertising agency, it's a difference that one is going to need the influencer to understand and make that difference. So this gets to the question of what is material. And the client says, well, we want to include customer reviews of the designs, and we encourage honest reviews, and we tell them to be honest, no matter whether it's positive or negative. But do the reviewers still need to disclose that they received free products? And the short answer is yes, because the issue isn't whether the influencer would be honest or not. The issue is what customers would think if they received a disclosure that the influencer had received free products. And so that's really the critical issue of materiality, is whether someone has received something and whether that's being disclosed to the consumers or whether there's a material connection in terms of a relationship with the company, either ownership of the company, ownership interest in the company, or some sort of familial or other relationship with the company. So in 2017, the FTC had a Q&A on influencers, and they specifically indicated that with regards to an uploading of a YouTube video, which is very common in a number of industries, including the beauty industry, that if the influencer was given free product, they need to disclose that. And here we have a proper disclosure. Acme brand gave me this product to try. Those types of disclosures are required. And with regards to video, the disclosure must be in the video itself, and it must be both verbal and written so that one can hear it, but one can also see it as well. With regards to the same Q&A session, the placement of the disclosure needs to be up front. That's the bottom line. It needs to be in the first 3 lines. It can't be buried at the back of a posting. That's not appropriate. And with regards to Snapchat, one has to have enough time to read the disclosure. It has to be clear, legible, and something that somebody can see. So basically, in terms of influencers, the recent takeaways are, if an influencer is paid and people know that that person is paid, there need not be a disclosure every time the influencer posts about a product, but a significant portion of the influencer's followers need to be aware of the relationship, and the influencer needs to disclose that relationship. If an influencer is hosting a giveaway funded by a third party, that needs to be stated with regards to the sponsorship by the third party. And it need not be a listing of everything someone has received. So if someone receives, for example, makeup and travel and other items, there can be a general description that includes all of those. It doesn't have to be an itemized listing, but there has to be a disclosure of that material relationship and what the influencer has received. An important factor is brands need to monitor and follow up with influencers with regards to what they do after the agreement has been signed, and there needs to be in the agreement compliance obligations. That is very, very important with regards to the influencer. It can't just be a written agreement that creates an obligation and then the advertiser or the agency looks the other way. With regards to built-in disclosures, the FTC has stated that it depends on the tool, but that one should not rely on built-in disclosures, and that conspicuous disclosure is required. Again, one should not assume that the built-in disclosures are sufficient. And the FTC has stated that their staff does not believe that the built-in YouTube and Facebook tools are sufficient. With regards to Snapchat and Instagram, again, the disclosure needs to be sufficient on the first photo so that it stands out and viewers understand what is going on and the material relationship. With regards to Pinterest, a superimposed disclosure on one of the photographs can work, but again, clear and conspicuous is the watchword here. So now we're going to touch on a number of examples. Some of these are more recent than others of FTC enforcement. Now, the FTC, the Federal Trade Commission, is a U.S. Body, independent commission, that basically is responsible for enforcement, especially with regards to unfair competition and misleading advertising in the context of what we're talking about today. And these cases are an example of past and present enforcement by the FTC. The FTC is like a policeman of sorts, but they, their resources are not unlimited, so that they usually go after the more egregious cases. But one can see by the trends in their activity what they're focusing their attentions on. So the first case, FTC versus Deutsch, LA, this is an older case, but it's informative because what happened was the FTC alleged that Sony and Deutsch LA is an advertising agency, that they misled consumers about the PlayStation Vita game console that was being released. And there was a great deal of hype about what the console could do and could not do. And also, Deutsch LA had its employees promote the new console in social media without disclosing that they were employees of Deutsch. And this was a no-no, and this was something that the FTC came down hard against. Now, this was a number of years ago, but the idea in social media of having your employees, whether it's the employees of the advertising agency or the advertiser, approve of and sort of tout the particular products is an absolute no-no without disclosing that they're employees. And so the net of that was the FTC barred Sony from making misleading claims. Sony was required to give consumers who purchased the product vouchers for cash or credit or for merchandise, and Deutsch LA was barred from making similar representations and was required to disclose in the future any material connection between an endorser of a game console product and their employees. So this was an early case, but as you'll see, it was a number of years ago, you'll see it's applicable still today. So next case is a decision that just came down in October, on October 21st, and it involves Sunday Riley. Sunday Riley is a skincare firm. It's been sold through Sephora. And what happened here was Ms. Riley and members of her company were posting false reviews of the Sunday Riley products, which are beauty products, and falsely representing that the false reviews reflected the opinions of ordinary consumers. Sephora had taken actions to take down some of the false reviews that they could tell were false, and the Sunday Riley folks still continued in their activity. And it went on for quite a long period of time, between 2015 and 2017. And as you'll see here on this slide, there was a direction given to employees, that everyone should create 3 accounts on Sephora.com, registered as different identities, and then promote the products of of the brand. And there were instructions, on how to leave different reviews, not to make comparisons, always to leave 5 stars. And this recent action by the FTC is, again, evidence that the FTC is watching out and that these activities are not permitted. Now, the interesting thing here is that there was a dissent by 2 of the FTC commissioners, Slaughter and Chopra, because there was no monetary penalty here, which is somewhat unusual. And usually the first one may not be a monetary penalty, but after that, there may be monetary penalties. So here, the FTC reiterated that the truth in advertising principles apply in social media, and that this would be something that they'd be looking at in the future. At the bottom of this slide, you'll see the response from Sephora, which basically they didn't know about it. They were not involved, and they apologized for the activity. But this case, as I said, which literally just came down a few weeks ago, is evidence that the FTC is watching carefully. I should also note that with regards to this case came to the FTC through a whistleblower. And so the whistleblower told the FTC what was going on, and then the FTC investigated and took action. In terms of best practices with regards to this aspect, if you're an advertiser, you should have a company policy regarding employee and vendor use of social media in this fashion. And if you do not, it could be a problem with the FTC. If you have a policy and someone violates that policy, you take action against that. But by having that policy in place, you're ensuring that as to the company, there is a policy, and that if someone is violating that policy, they're sort of a rogue agent as opposed to following a company order or the order of a client. There should be training and guidance with regards to the enforcement guides for employees, and to the extent that vendors are being used, you should also make sure that the vendors understand the basic rules of the road. With regards to making sure, as we said before, with the influencers or the advertiser, making sure that if there is a violation, that action is taken, and that possibly, if necessary, if it's an influencer, that they're terminated if they violate, the FTC enforcement guides. And with regards to this, the idea, and it's probably obvious to everyone on the call, but social media is very effective as a tool. It is also important to use social media in terms of measuring the effect of different types of social media. So working in that monitoring of response and remediation should be a part of that effort. Again, with regards to employees, just hashtag employee is not sufficient. One has to disclose the name of the company or indicate that it's my company. So another oldie but goodie is this case in Ray Warner Brothers Home Entertainment. This was a video game related to the Hobbit and Lord of Rings, Middle-earth, Shadow of Mordor, and Warner Brothers had hired and paid online influencers, given them an advance copy of the game to develop and promote on their YouTube and Twitter and Facebook. There were not proper disclosures made, and the influencers FTC issued a consent order, and basically Warner Brothers was required going forward to make sure that the influencers disclosed that the gifting of the videos was from Warner Brothers, and that their information with regards to playing the game and how to play the game, that was sponsored content, and that Warner Brothers had compensated them. So again, this is an oldie. This is 2016, but as one will see, there are later cases where these same principles apply. So what about native advertising? So native advertising, which I'm sure everyone knows, is sponsored advertising. It's an article about a particular product or a service, but it looks like it's news reporting. And so, as we'll see, that also has come under the FTC, under their scrutiny, and again, disclosures are required. So the most recent famous case is FTC versus Lord & Taylor. Lord & Taylor was launching a design collection that was an in-house collection, and they used the online publication and social media of Nylon. And the contract with Nylon required that Lord & Taylor would review the posts and approve the post. Lord & Taylor paid 50 online influencers to post Instagram pictures and to style themselves wearing a paisley dress from the collection, and they all came out at the same time, which that sort of led to people on social media thinking that something was up, that 50 influencers all would come out at the same time touting the same paisley dress. So while the influencers were free to style the dress, they were required to use the hashtag at Lord & Taylor and hashtag Design Lab in the caption of their photo. And oddly enough, Lord & Taylor did not require disclosures, and none of the influencers made disclosures. So the result, which shows the power of social media, was immediate and great. They reached 11.4 million individual users in just more than 2 days, and there were 328,000 brand engagements. And the paisley dress sold out. But the FTC caught wind of it, and because of the failure of disclosure in the Nylon article and in the Instagram posts and social media posts, basically the failure to disclose that the influencers were paid between $1,000 and $4,000, the FTC took action, and in 2016, they settled with Lord & Taylor. There was an order basically preventing such activity in the future. And this was really the first case dealing with native advertising. Again, as one will see in the last bullet point, Lord & Taylor was required to establish a monitoring and review program for endorsement campaigns, which included provisions for terminating any endorser with a material connection that didn't disclose it. And this is basically, the standard operating procedure. This is what's required. And one can't just set up a system and then let it go and look the other way. There is a requirement of monitoring and review. So following those cases, the FTC has, in a series, and it's happened basically twice, they've issued letters to influencers. And these aren't just, happy-go-lucky letters. These are letters where basically, in response to consumer groups, which complained about the need for disclosures and sort of how non-disclosures were rampant with influencers, the FTC issued a series of letters to influencers and some to brands saying that if there's a material connection, it needs to be disclosed. And it's interesting because in subsequent actions, there have been additional complaints on this issue that influencers who received letters hadn't followed up, hadn't taken proper action. And so this is sort of an issue that certainly if you're working with the influencers that the FTC has sent letters to and you're a brand, you should be aware of that, because that may be something down the road that could, even if you as an advertiser or an agency are acting properly, if the influencer has received letters basically saying that they need to comply, that may affect your brand. And certainly, as we just were talking about, in terms of having a monitoring and compliance system in place, you definitely want to have that in place with regards to influencers that have already been the subject of scrutiny by the FTC. And FTC to the influencers and to some advertisers made it clear that certain disclosures are not sufficient, as again, the hashtag SP or thanks brand or hashtag partner. So this is the FTC sort of laying the record so that at a later point, someone can't really say, oh, I didn't know, I wasn't aware. They've been making it clear in letters to the influencers, in the Q&A that we talked about, that was an online Q&A. This is the way for the FTC to let people know what is appropriate and what is not appropriate. So in 2017, the FTC took its first action against 2 online gaming influencers with regard to basically their ownership in a company that they were promoting online and endorsing online. And in their endorsement, they did not disclose that relationship. They did not disclose compensation. And they had asked other gaming influencers to promote, again, for these payments of, the low was $2,500 and the high was $55,000, without requiring any disclosure. And this is interesting because there was no admission or denial of the allegation, but there was a consent order, which enjoined them from, again, misrepresenting an endorser as an independent user. Again, the penalty here was not that great, but usually that happens where you're maybe the first or second enforcement action, and once it becomes clear what is accepted and what is not accepted, the FTC will become much more stringent and aggressive with a demand for a penalty. In 2018, in February, the Brazil Olympics was coming along, and there was a promotion by athletes of a new mosquito repellent, and called FIT, or Fit Organic Mosquito Repellent. And so with this, there were paid athletes endorsing the product. Again, there was paid for advertising, which was native advertising, and the FTC came down hard on Creaction, which was the company behind it, and they prohibited again, the false representation. They prohibited the native advertising without disclosure, and the influencer opinions, which were paid influencers, passed off as independent consumer opinions. In March of this year, Truth in Advertising wrote to the FTC and complained that 20 social media influencers, notwithstanding the 2 sets of notice levels, were still not making proper disclosures. And they gave 1,400 examples regarding 500 companies. So again, this is pressure on the FTC to take action. Again, if you're considering influencers, or whether you're an advertiser or an agency, one might want to look at these examples, because this is Truth in Advertising complaining about it, but the FTC may take action down the road. And so one wants to be clear as to the potential risks with regards to influencers. Again, with regards to the timing of this, this is the 4th influencer complaint made by Truth in Advertising. And there, with this slide, you can see some of the different influencers and posts that were the subject of the complaint. Again, this just happened. It happened on the same day as the disclosure with regards to the beauty products. The FTC sued Devumi in Florida, and there was a settlement. And this was the first FTC complaint challenging the sale of fake indicators of social media influence. So in terms of followers, and basically the buying and selling of followers. And there was a monetary judgment of $2.5 million. Devumi went out of business, but the idea here is that people use fake indicators to basically misrepresent the level of influence that they have. And this included not only influencers, but musicians, lawyers, athletes, a whole number of different folks. And according to the FTC's complaint, Devumi filled more than 58,000 orders for fake Twitter, more than 4,000 sales of fake YouTube subscribers, and 32,000 sales of YouTube views for musicians. So this is another area that, in terms of advising your clients, it's not acceptable. And this is the first case. Basically, as I said, Devumi basically went out of business. They had to disgorge all the money they made from this. And my guess is that there will be others to follow. Couple of things to mention with regards to sort of the international aspects of FTC enforcement. So in March of this year, the FTC signed a memorandum of understanding with the United Kingdom's Competition and Markets Authority, the CMA. And the CMA works with the Advertising Standards organization in the UK, and it's a little bit of a different enforcement mechanism. That they will take down ads, but there has been activity recently by the ASA in terms of taking down ads where disclosures have not been made. So to the extent to the extent that your advertising is cross-border, you want to be aware of this. and thus far, I would say the ASA is probably a little more aggressive than the FTC, but the fact that this memorandum of understanding was signed indicates that there will probably be cooperation between the two organizations with regards to enforcement. The CMA released in January a influencer guide. Again, this is putting influencers on notice with regards to what is required and what is not required, what's permissible and what's not permissible. The British or the United Kingdom system is a little bit different in terms of how things are regulated, but it's generally a similar outcome in terms of disclosure of compensation, transparency with regards to use of the product, and being clear with regards to a relationship to the brand of any sort. So November 5th, which is just a few days ago, the FTC issued a guide for influencers. And we have a blog on our fashion and apparel blog and our advertising blog if you want more information on this. But it's basically Disclosures 101 for social media influencers. And they did create a video for people to see. And this is a shout out to influencers saying it's your responsibility to make these disclosures, to be familiar with the endorsement guides, and to comply with the rules with regards to proper disclosures and deceptive ads. And it gives tips, but one can only imagine that this is the prelude to further enforcement by the FTC. Some of the tips that were given with regards to endorsements in a picture on a platform like Snapchat or Instagram, one should superimpose the disclosure over the picture and make sure viewers have enough time to notice and read it. With regards to a video, as we noted earlier, it should be both in audio and video, and it should be at the beginning, the description of the video, and at some point in the video. And with regards to live stream, the disclosure should be repeated periodically so that viewers who only see part of the stream or receive only part of the stream get the disclosure. So we're coming to the end of the presentation. What's the bottom line? The watchword here is transparency. An advertisement or a promotional message shouldn't just suggest or imply to consumers that it's anything other than an ad. And this is sometimes tricky because oftentimes clients do not want to hear that. They want to somehow skirt between it, but the FTC has made it more and more clear that the guides apply to social media, they apply to native advertising, they apply to social media posts. And this is an area that is not only aggressively being enforced in the US, but as we noted in the UK, it's also in France as well, and around the world. The level of enforcement by different agencies around the world varies. But if you're doing advertising that's hitting social media, the way this works is the U.S. will enforce social media posts that come from outside the U.S. and hit the U.S. Social media consumers. With regards to social media influencers, they must disclose any material relationship between the brand and the influencer. And that is not only a requirement of the influencers themselves, but it's part of the requirement for the advertiser and part of the requirement for the agency, because if a proper disclosure is not made and there's no compliance and there's no follow-up, that's going to affect the agency and it's going to affect the advertiser. So in terms of the executive summary, just to recap, clear and conspicuous disclosures, make it clear what is going on. Sometimes clients do not like that because they, people, if they see advertisement or they see sponsorship, it's a turnoff. So sometimes the way to get around that is maybe to write something and make it more of a narrative. So that if you have a celebrity that says, thank you to Acme for the wonderful makeup that you sent me, I'm trying it out and I love it, that's a sufficient disclosure. It sounds better than hashtag ad or hashtag paid, those types of things. As is clear, hopefully from this presentation, the FTC is focusing on endorsements in any shape, color, size, so that if it's social media, it's covered and they're looking at it, whether it's native advertising, whether it's buying, support for your particular, post, or whether it's making posts and making different social media posts about a product. It basically is covering everything. And just some watch words. The cost of avoiding risk is the cost of being prepared. It's not if you do it in the proper fashion, it isn't a great cost. Having an employee and vendor policy in place and making sure that that's part of your employee manual, for example, it's not an extensive cost, but the cost of not doing that could be a great cost. Having agreements, written agreements in place with influencers, bloggers, advertisers, and celebrities, it's essential and it's standard operating procedure. And monitoring social media usage by employees, influencers, bloggers, and celebrities to ensure that proper disclosures are being made is essential. As I said, the FTC is scrutinizing social media, so you want to be prepared and be careful. Now, that is the presentation, and thank you. And now, if there are any questions.
So, sorry. Thank you, Ted. We are now going to start the question and answers. So we have some interested question here. Okay, how can one ensure that an influencer complies with the requirements of disclosure?
So, as we noted, in terms of any system, you want to have, as part of your contract, you want to have consequences if they do not comply with the disclosure requirements. And the disclosure requirements should be part of a standard influencer agreement. And if the person does not comply, and so you have to have a monitoring system in place, then depending on the contract, depending on the nature of the relationship with the influencer, it may be one strike and you're out and you're fired, or it may be, you have to make the proper disclosure and they can correct the situation. But there should be some sort of penalty if they fail to make a disclosure and once told about it, they failed to correct the failure of disclosure. I see that there's a question in terms of what are the typical penalties from the FTC in these instances. That varies on the particular facts. And so, as we can see from the presentation, with regards to the Sony case, the penalty there was basically giving consumers who had purchased the product a coupon for cash and a coupon for product. There have been some cases where there's been no monetary penalty, and in terms of the Sunday Riley case, that was the complaint by the commissioners, that there was no financial penalty, but I think that was because it was an early case. And then there have been some cases where there have been greater financial penalties, such as the case that we were talking about where people were buying the Devumi case, where in that case, the penalty, the company went out of business, so how much they can pay is a question, but the penalty was as high as 2.5 million if they can pay that. So if they have that, they'll pay 2.5 million.
Wow. And we have one last question for Ted. So do you think the FTC will be increasing the level of enforcement of influencers?
So I think the indicators are that this is not only important in the US, it's important all over the world because, as we pointed out at the start, social media is where a great deal of advertising is going. And because it's such an important part of advertising for consumers today, the enforcement will increase. And I think the FTC, you can see it in the progression of the activity. You can see that they are getting more focused on this, and they are devoting more time to this. So I think, as we see in the Sunday Riley case and the Devumi case, which are just from a few days ago, the enforcement is there, and I think it will continue.
Thank you, Ted. We are coming to the end of our time here, so I would like to thank you all for your participation. Thank you, Ted, for this very engaging presentation.
Thank you for the opportunity to present.
If you are interested in joining the FACC network or have questions, if you're already a member, feel free to reach out directly to me. This presentation will be available on our website and sent to all participants. We hope to see you at upcoming FACC events soon. And thanks again, Ted, and thank you, everyone.
Thank you very much.